Court, all rise.
Good morning.
Good morning, Your Honor.
Court's in session. You may be seated.
May I proceed?
You may.
Your Honor, this is docket number 1881 CV 2385, City of Waltham versus the Trustees of the Stigmatines Fathers. Could parties please identify themselves for the record?
Attorney John Cervone, City Solicitor, City of Waltham.
Attorney Michelle Learned, Assistant City Solicitor for the City of Waltham.
Good morning, Your Honor. Jason Scopa for the Stigmatine Fathers.
Good morning to council. You may all be seated. So I want to go over a few preliminary matters and get some additional information from the parties. First, I'm going to turn to the plaintiff moving party. The defendant has raised in its opposition, and it appears to be an accurate factual assertion, that, well, let me go back. It appears on the record that the town filed an opening brief, and they also filed a reply brief. And that reply brief was 20 pages. Is that right?
Yes, Your Honor.
It's actually 22 pages.
Correct, Your Honor. They cross-moved for summary judgment, and so it's our opposition to their cross-motion.
Did you seek permission to exceed the 10 pages of the reply brief?
Your Honor, when it's the opposition, respectfully, any oppositions to cross-motions are entitled to the 20 pages.
All right. In the defendant's opposition, you indicated, or in the defendant's opposition, the defendant rightly indicates that you have failed to comply with the requirement with regard to font, with regard to the margins, and with regard to the spacing. And the defendant makes the point, and I think it's a point that's a point of fairness, that your brief essentially is a 30-page brief, and I guess your reply would be in excess of that since it's 21 pages or 22 pages. Did you see that information in the opposition?
I did, Your Honor.
Did you respond to it in any way?
I did. In the opposition to their cross-motion at footnote 1, I indicated, sorry, Your Honor, I'm sorry, at footnote 2, it's our contention that the city's brief does comply with Superior Court Rule 9A.
How is that?
5 for font size. It is 12-point font, New York Times. Its text is 12-point font, and it is double-spaced. The double-spaced is the same double spacing per vertical inch that is used for appellate briefs. Rule 9A does not regulate the size of margins. And then to the extent that it did exceed the 20-page limit by 1 page, the city did request leave of this court at that time, given the complexity of the legal arguments at bar. But when you follow...
And where is that, though? Because I don't see that in the docket.
Sure, it's at...
No, the approval by the court for you to get an oversized brief.
No, Your Honor, I'm sorry. We didn't make that request. We made it via the opposition to the motion for cross-summary judgment.
All right, it's denied. I'm kicking the brief back, and I'm going to tell you why in a second. I want the parties, I think the parties are both missing the point here. And I've done some research on the law here. What appears to be happening here? Oh, before I do this, I want to get some more information from the town. The June or July 10th deadline, what happened on July 10th?
If I may, Your Honor, and that's the subject of the emergency motion I filed. We proceeded forward with the MSBA, but what happened very recently, and I was not given a copy of it until I found out, the MSBA, once again, the defendant filed a sabotaging letter to the MSBA, which caused our We were supposed to be in front of the MSBA today for a final vote on our grant funding. Because of the letter that they filed.
So what happened on July, as I understand it, in the prior briefing, you informed the court that if the case wasn't heard by July 10th, that you were going to lose your funding, no further extensions. What happened between July 10th and August 28th?
Between July 10th and August 28th, we went forward for a subcommittee hearing before the MSBA. And because of Judge Erasha's 15-page decision, which removed defendant from the property,
Yes?
that subcommittee of the MSBA voted to send it forward to the MSBA for a final vote on our 115 to 20 million grant hearing, which was scheduled for a final vote today, but was taken off the MSBA's agenda after the defendant filed a letter on 8/21 with the MSBA, totally ignoring Judge Erasha's decision and alleging that they have evidence and law that absolutely confirms that our taking was invalid. Therefore, because of the defendant's fourth letter to the MSBA, we were taken off, and the MSBA full board will not vote until a decision of this court is issued on the summary judgment, which is the basis for the emergency motion for an attachment.
I haven't looked at the motion for the emergency motion for attachment, and I will say if there's a true emergency, I'll take a look at it. But if there's no emergency, I'm going to give the defendant a chance to respond to it in the normal course. Here's the issue that I think that the parties have not addressed that needs to be addressed. Both of you have skirted around it, but it just doesn't seem to be getting me to the law that I need. Under the eminent domain statute, as articulated by the legislature and as amended now, both in 1962 and 1982, the defendant landowner has a period of 3 years in which they can raise a challenge to the validity of the taking and or to an assessment of damages. That is a statutorily provided right. Here, they have not so exercised that right yet. They just haven't. What you're asking me to do in this declaratory judgment is to truncate that 3-year period or to accelerate it by virtue of your claim for declaratory relief. Because your claim for declaratory relief, and I think I brought the complaint out here, but if I didn't, I can go back and get it. I do have it. In your prayers for relief, you ask for, in prayer 4, a declaratory judgment in favor of the City of Waltham, declaring that the city's use of the power of eminent domain to take 554 Lexington Street for school purposes in open space, or a combination of thereof, was for a valid public purpose. In doing so, you're asking me to declare judgment on what would normally be addressed in an underlying eminent domain pleading brought by, statutory allowed for, by the defendant landowner. And you ask that it was valid and therefore not made in bad faith. And then the second part of the declaratory relief that you're asking for is that Waltham has and retains sole ownership of this property. The second part of what you're asking for is the easier nut, because that does not impact what I believe is the defendant's statutorily protected right to challenge the validity of the eminent domain anytime for 3 years following, I'll say, the filing of the order. But the first part of it squarely is asking me to resolve the issue of eminent domain on its merits, which the defendant has 3 years to raise by statute. And so, when I look to the cases that you have sort of cited me to, and that is why your briefs act or appear to be arguments on the merits of the eminent domain issue, because in fact you are asking me to decide the merits of the eminent domain issue. The question then becomes, can you, the effect of me allowing the town of the City of Waltham to pursue offensively a declaratory judgment action that would effectively truncate the statutory 3-year time period prescribed by the legislature to bring a challenge to the award for or the validity of a taking by the defendant. That's what in substance you're asking me to do. And the cases that you've cited to me for that stand for the proposition that I can do that or that you could do that aren't authority. They are situations in which the defendant landowner had either precipitated or brought a counterclaim asserting their eminent domain argument. And that's exactly what hasn't happened here yet. The defendant hasn't asserted. And I think the statute gives them 3 years to do so. So the cases that you've cited me to, I'm going to give you a chance to chime in here. But I want you to know a couple of things. I want briefing on specific to this issue. This is the central issue of the case. Can you, by bringing this declaratory judgment claim, truncate or precipitate them having to bring it? It seems to me that the legislature put this right in place to allow the defendant, landowner, 3 years to make this decision. And I'm not sure that any offensive use of the declaratory judgment claim here is permissible to the extent that it goes beyond giving you the ownership part of the declaratory judgment relief requested. Now, at the end of the day, part of the reason why I didn't just kick this brief back and I wanted you to actually come in and see my face and actually argue about these things is because I'm not sure what the town really needs. You say in your brief, all you need is the last part of the declaratory judgment that you're asking. That's all that the state agency, I'm going to get it wrong so I won't even use the acronym, that's all the state agency is asking you for now. They want to know that you own it free and clear. But you ask for in your prayers for relief something far greater than that. And the far greater than that, which is a disposition on the merits of the eminent domain claim, require me to address this issue of can I truncate? Is it permissible for me, for you, to offensively use the declaratory judgment statute to truncate that statutory right provided for in Section 16? That's the issue that's swirling in my head. I want you to address that issue in a comprehensive way. It is sort of passed through in the plaintiff's briefing, and I'll say it's passed through in the cases that I'm saying that I don't think get you where you need to go are the Stockbridge case, because that is not an offensive use. It is by the taking authority as you're attempting to use the statute, nor the DiBiase case. That is not an offensive use either. It's a case in which the landowner is on board with the resolution of the eminent domain dispute. So neither of those cases stand for the proposition of what you're attempting to do, which is affirmatively raise this issue and force the defendant, in this case, to litigate the issue of eminent domain before the 3 years is over. So with that by way of background, I'll hear from the plaintiff.
If I may, Lynn, I understand exactly what you're saying, and with all due respect, as I read Town of Chelmsford, well, I'll start with this. Every declaratory judgment action is by its own nature affirmatively offensive. One party in a potential dispute, decides to bring a declaratory judgment action. That's the whole purpose of Chapter 231A. And if I may, I understand the question about what Chapter 79 created in 3 years. It's a statute of limitation. That's all it is. It's a statute of limitation. It says they have 3 years to bring, no different than a 3-year tort statute of limitation or a 6-year contract statute of limitation. So somehow a statute of limitation isn't turned into a right. If I'm in an intersection accident with the defendant, and I say he caused it, and he say I caused it, and I say I want to resolve this now, I have the ability to bring an action. He can't say I have 3 years under the statute of limitations, so you can't do it now.
If you brought an action, if you had a car accident with somebody, and you decided that you didn't think you were weren't responsible, and you brought an action to declare, I'm not responsible for this action, what do you think that would happen to that case? If you had not been charged, if you had not, there was no claim that you were responsible, it would be thrown out, wouldn't it?
I don't believe so, Your Honor.
Well, I believe it would. I believe it would be. There's no claim against you. Nobody's saying you did anything wrong. It's putting the cart before the horse.
Well, if I may, that's any contract action, any tort action where the two parties have disagreed. One party is allowed to initiate it before the end of the statute of limitations period. That's the nature of it. I mean, that's exactly what happened.
Well, you're going to have to prove it, and it's not in these cases. I did not find one case in where I'll call it the offensive use of the declaratory judgment action. You know what I mean? I'm using it as a shorthand. I have not found one case in which there's been offensive use of the declaratory judgment statute to precipitate the defendant having to raise that their claim that there was a not a valid taking or an assessment of damages type claim. They're just not there.
As a practical matter, Your Honor, again, respectfully, what is being suggested is something that would stop every public works contract and every public works taking in this state.
How do you get that?
If $1 million roadway projects, school projects, $1 million Mass Pike projects had to wait for 3 years to determine whether the takings that are necessary for those projects are going to be valid, or if someone might raise them in 2 years and 364 days, they would not risk all this. Nothing would get bonded. The big bonding that goes through for most of these projects would never pass bond counsel if it was possible for one of the landowners whose land was taken to wait 3 years.
And if it was possible for you to do what you're suggesting, affirmatively raise this in a declaratory judgment action, wouldn't there be one reported case in which somebody else had tried to do so? I don't find one, not one case where this statute has been used affirmatively. So your argument perhaps proves too much. That is, there's no one else like you out there that I can see, where the town has been, the person who has taken the property is affirmatively seeking in a declaratory judgment way to get eminent, to ensure that they're eminent domain rights.
If I could, Your Honor, my co-counsel has looked at the cases maybe more extensively than I have.
Your Honor, if I
Is there some other case that you've cited that I haven't mentioned?
Yes, Your Honor, there is.
What case would that be?
Sure, it was on pages 15 through.
Give me the name of the case.
I'm sorry. So Chelmsford. Okay, they did that one.
Chelmsford is not helpful. Both parties there.
I hear you, Your Honor. I also cited Inhabitants of the Town of Watertown versus Dana. It's an older case, SJT case from 1926. And I also cited Commonwealth versus Quincy Memorial Company, Inc., which is an appeals court case from 1926.
I don't think either of those cases. You're going to have to go back and take a look at actually what those cases stand for. I have now crystallized the issue for you. And here's another thing that I'm going to tell you. I do not want briefs. I will tell you, I came from the federal side of the house. If your brief had come into the federal court, it would have been kicked back immediately for noncompliance with the rules. You need to go take a look at what the rules are. This is in 8th grade, and I'm not the teacher that gives you 20 pages and say, oh, if I change the font and if I do X, Y, and Z, I can get it on to 20 pages or 21 pages. Make it look like it's supposed to. If you have any questions, go down to the clerk's office. I want it in 20 pages or less. Do you understand?
Yes, Your Honor. May I make one? I need to address one issue that you raised. There is not a statutory right so the statute of limitations period of the 3 years is for damages petitions. It's not a statutory right for the validity of the taking.
All right, I'm reading from Cumberland Farms, and it says the person whose land has been taken by eminent domain has 3 years from the time that right of damages is vested to lawfully contest the lawfulness of the taking.
Correct, Your Honor. Cumberland Farms was, in fact, an equity case. All of the challenges to the invalidity of
the taking
challenges come through equity challenge. They come through Chapter 231A, Section 2. What the case law has said is that they can use the 3-year statute of limitations period that is statutorily set out for the petitions for damages. So,
right.
And I think that's a very important distinction.
Well, I'll tell you, it's in the dicta of many other cases, to include the town of Sherburne case and other cases. It may be dicta, it may not be controlling, but because it's not the holding of the case, it's mentioned in passing. But there, in that case and in others, the appeals court and the SJC, depending on who's the writing authority, are making statements with regard to what 79 Section 16 allows is permissible.
If you look at the...
and it's not just limited to assessment of damages.
All of the cases that discuss invalidity challenges stem from equity actions, and they permit parties to file the invalidity claim within the same time period. It's case law that says within the same time period as that is statutorily granted for the petitions for damages. I think that's a very important distinction, Your Honor. We have case law that exists that says upon the filing of the taking order, title vests with the city. So were we to adopt I can sit back for 3 years under that, by adopting that statutorily right that's granted to damage petitions, you are at odds with the case law that says title vests with the city.
No, title vests with the city. That's why I said to you, if I was just if it was what was before me was simply the last paragraph or the last clause of your prayer for relief, that's a simple question.
However, 231A, the language of 231A specifically says that determinations of the instruments related to property rights are able to be made under 231A Section 2. The statutory 231A Section 2 often cuts off people's statute of limitations on a particular claim because it's designed and set up to avoid litigation. Ample case law.
All right, so find me case law that relates to the eminent domain statute. Is there anything out there that says you can use Chapter 231 in this way to amputate the statute of limitations, or to shorten the statute of limitations?
There are sections of Chapter 79 itself that indicate that you're not able to sit back on your rights, given
Now, answer my question.
I have not found, oh, actually.
Are there any cases
there
that
is-
even
there is
truncate, they allow you to use the declaratory judgment action to truncate any provisions of Chapter 79?
There is a Superior Court case out of the city of Springfield where, Superior, I didn't cite it. It is Superior
Well, you're going to get an
Court case.
opportunity because this is where I'm focused like a laser. A lot of your other argument that's in the briefs, in the however many pages of briefing, really to me, this is the issue that needs to be decided. Much of the briefing on both sides, I will say, is not helpful for me to resolve this dispute. So in some ways, you do me a gift by filing a non-compliant brief because I get the opportunity to tell you what it is that I'm focused on and I think that is important to resolving this issue because I don't really see it in your briefing. It's passed through in your briefing and it's passed through in your standing argument in the defendant's briefing. But the far more direct route for the defendant was they can't do this. I have 3 years to raise this argument. And that you raise it as a standing issue, but it really is that there's no case in controversy here until I raise it.
May I be heard, Your Honor?
Yes.
And for the most part, for this morning's purposes, I'll just rely on Section B of my argument. But if my brief is compliant, my cross motion for summary judgment, and adequately addresses that issue, and respectfully, I think it does. I think we've made it clear that essentially, to really shorten it, you can't do this. And if we've made that argument sufficiently, and I think we have, I ask that you dismiss count one of the complaint if this brief is compliant. I think it is.
What brief is compliant?
My cross motion for summary judgment.
Your brief may be compliant. I didn't see anything wrong with it. But if I'm kicking back their brief, you're going to get. I'm not going to allow you to just them have no brief. I'm kicking it back. I'm not striking it.
Understood.
Respectfully, Your Honor, I did, at pages 15 through 20 of the opposition, spend quite a significant time on the standing issue. And in addition to those arguments, the only case that I have found that would support the city's argument, in addition to those cited, is a Superior Court case that I believe Justice Sweeney decided. The city of Springfield brought the case in the exact manner as we did. It's a little lengthy. The court ruled against the city, not on the standing grounds, on the merits. And the case was not appealed. I do think that some of the arguments, though, at pages 15 through 20, set forth that there is a distinction between how all of the cases that discuss invalidity claims are equitable actions, and that 231A Section 2, by its very language, says property interests are able to be decided, including the instruments that give those rights, and here the instrument is the taking order, and that those, with that instrument, the validity of the taking, the bad faith allegations do, good faith allegations do come into play. Yeah, exactly. Sorry. Judge Eurasius already determined that there was no bad faith on the part of the city with respect to all the documents that she had seen thus far. And also decided that the public policy here is so great with respect to the damage that the school children of the city, 5,300 students, could be impaired by the lack of the city receiving the $126 million of grant funds. And so
But Judge Horatius was looking at a very different issue than the one you're asking me to look at now. I've read her opinion. I'm aware of it. I'm also aware of the simple fact that it was the town that chose to use this land to put their high school on it. Doing so could have played out in a variety of different ways. The way they chose to do it was they chose to take the land by eminent domain, as opposed to reaching some agreed to amount of money that the defendants would have taken. Maybe there was no agreed to amount of money that the defendant would have taken. However that came to pass, we're here today. And the issue that I need to decide is, yes, I understand that there's perhaps a crisis might be the too strong of a word, but there's a grave concern within the town as to whether or not they're going to be able to build this high school timely. And if so, what the long-term ramifications of that might be. But the town made the choice to put the school on a property that they took by eminent domain, and there's statutory consequences of that. It is always within the parties' ability to agree to a waiver of whatever rights Chapter 79 grants to the landholder, and that's always a possibility. So I encourage you, if you haven't already started to discuss or rediscuss some of the issues. As I understand it, the defendants are now off of the property. They are still very much maintaining that there's been some bad faith, and they are still seems to be maintaining that they have a claim that the eminent domain taking was not valid. But the dynamics of the situation have changed perhaps since the last time you were sitting around the table. Maybe. I'm up at 20,000 feet. One simple solution to this is to get a waiver, and you know how to do that. I am not saying, so in your briefing, that's my 2 cents on settlement. Start talking to each other again. This could last, I think you all know this, but to the extent that we're going to go forward with this briefing, and I'm going to hear this, I want briefing within the month so that I can continue to sit on this. I'm going to be here in Woburn for the rest of the year anyway, sitting criminally after the end of the month. But I want you to focus on other cases as close as you can get to this situation. I believe, based on my review, there are no eminent domain cases out there in which there's been, and I'll call it, an offensive use of the declaratory judgment statute to precipitate the meritorious resolution of an eminent domain validity claim. I don't see it out there. So you're going to have to go to whatever else is the closest cousin to that. There may be cases, I don't know, whether the declaratory judgment action statute has been used to affirmatively truncate other statute of limitations that are provided in Chapter 79. I don't know. I don't even know what other limitations there are in Chapter 79, or the closest comparable you can get to it. But there's a live question in my mind, given Chapter 79, Section 16, whether or not the town can affirmatively precipitate that resolution on the merits, given the 3-year time that the defendant has to raise it by statute. That's where I want you to focus your briefing. Because if I don't have the right, if that right doesn't exist, that is, if the declaratory judgment action can't be brought affirmatively, then it seems to me that the defendant has 3 years to raise this. Now, in most instances, they would never avail themselves of the 3 years to raise it because they want their land back. So this fact situation may not play out very frequently that it is that your side had to be on the offensive. But here we are today with you trying to use that statute in a way that I think would limit the defendant's later right to avail themselves of the rights that are provided by the legislature in Section 16.
In the interim, Your Honor, would you be inclined to resolve the title issue as you see? I believe the defendant's papers did concede that Chapter 231A could accomplish the title, that title full use and control does at this time rest with the city.
I believe, Your Honor, I did say something to the effect that that's the most that they could ask for by way of a declaratory judgment, and perhaps that would be a valid request. And I don't think it's before the court, but if it were before the court, it would need to still be entered without prejudice to the landowner's 3-year right under Section 18 of Chapter 79 to challenge the validity. I believe that was how I addressed it, I hope. And again, it's not before the court yet.
This is what I want you to do when you're doing the briefing. I want you to look at the prayers for relief and assess them separately, because Section 4 of your prayer for relief asks for two very different things. One of them is, let me find it again because it's in a heap of papers here. Here it is. One of it asks for that Waltham has and retains sole ownership of this property. Okay? And if the defendant has an objection to that declaration, then you're going to need to oppose it. I don't think he ceded it in his brief. I think the closest he got to ceding it is that's the most that they could say. If you don't have an objection to that, then let's not fight about that. The bigger fish is the first part of your ask in the prayers for relief 4, which is basically you're asking me to decide on the merits whether or not there was a proper eminent domain taking. And that raises the issue that now we've spent a bit of time discussing. My quick look at the first issue, I think the winning shoe goes to the town. But I need to give, if you're going to somehow change your prayer for relief or just seek summary judgment as to that limited ask, then that needs to be made clear in writing on the record. And that may be all you need based on what I read in your pleadings. Because that may be enough to satisfy the financing authority based on what you put in the entry salvo of your first brief. That may, as a practical matter, still leave the town with the reality that the defendant has 3 years in which to challenge the validity. That doesn't mean that the school can't be built. There may be other risks associated with that. And that is why I go back to mention again, as I will probably for the last thing that I'm going to say substantively, is start talking again. There is an easy way out of this, and that is to get the defendant to waive.
To address the court, we've attempted that even before. That's why we
Since they've moved out?
No.
Have you had any discussions since to me, that is a sort of a watershed moment, because they were fighting that tooth and nail, it seems, from what I read, and I didn't delve into it too much because I needed to focus on the ball that I need to focus on. But it seems to me that there were months and months and months where that didn't look like it was going to happen. And there is a sea change. They are now gone from the property. Right?
Yes.
Well, except one.
Is there somebody still there?
We're allowing, it was one person who was having a problem.
Okay.
We've allowed them to stay on temporarily, just as I've made myself available to let people in to remove things like that.
And I will say to the defendant, this is not all lopsided. I mean, when I look at the record, the little I've looked at it, the bad faith argument is going to be a steep road to hoe.
Understood, Your Honor.
And if I may, Your Honor, just on that one issue and how it is a nexus with your other point.
Yes?
The reality is, and this is in evidence and documented, the only case that the defendant has ever tried to argue that substantiates its allegations of bad faith is the Pheasant Ridge case.
Right.
And the Pheasant Ridge case basically says, if the town could show it had previously thought about acquiring the
There just was,
property.
it was absent. There was no evidence that the town, I read the case. There was absolutely no evidence. I think it's distinguishable, which is why I said what I just said to you.
Exactly. And my point is later on in the case they say, if there was evidence that the town had previously considered acquiring the property,
We wouldn't be
et cetera,
making this holding.
we
wouldn't be finding
That's
this.
absolutely correct.
I read it. I read it.
And they cited the Chelmsford versus DiBiase case and affirmatively approved that language, which basically says, if you can show either the city either had previously shown interest or listed it as one of the sites it was going to acquire, that would prove good faith, which affirmatively makes it impossible for defendant to ever prove bad faith. On the stand and in evidence are documents by which the defendant admitted they knew that the City of Waltham had previously obtained 2 contiguous parcels as part of its overall master plan and listed for years previous the acquisition of this property. So it's legally impossible for them to ever prove bad faith. That's why since the I think it was 1988 that the Pheasant Ridge case was decided, shortly after that the legislature passed the Community Preservation Act, which basically, that's why Pheasant Ridge has never been cited again. It has become defunct because of the passage of the Community Preservation Act. And on the other issue, the obverse side of, and I understand perfectly what you're saying, and I think it's because it's so, as a practical matter, the need for government to move forward explains why there are no Chapter 79 cases.
But there are a whole, and I don't want to get into this whole argument about this, but your mention of the public roads projects raises a whole host of other different issues relating to right-of-way cases that are different than the setting that we're in here. You'll see there's a distinction under the law. I started to read some of them, and I'm not sure. They may be persuasive authority for you, but I don't think that's going to be where your money argument's going to be.
I understand, Ron. But by the same token, there is not a single case that says that the statute of limitations in Chapter 79 or anywhere else can be used offensively.
He's not trying to use it. How is he trying to use it offensively?
He's saying you can't bring a even though Chapter 231A gives us the ability to bring a declaratory judgment action, he's saying you can't do it. 231A is trumped by the statute of limitations in Chapter 79. There are no cases that say that.
It's not saying that. He just hasn't brought an action. And he's not pleaded in a counterclaim either.
And Chapter 79, Section 22, with all due respect, says whatever you do, when it doesn't make any difference who brings an action, but it says any claim, defense, etc., not raised after the filing of the action is waived.
And that goes back to my point as to whether or not there's a case in controversy here.
And Your Honor, Section 22 speaks only to petitions brought under Section 14, which is for damages. It has nothing to do with validity.
What? I don't know what you mean.
All right.
Thank you, Your Honor.
How much time do you need to get this to me?
Like 2 weeks.
Yeah, no more than that.
2 weeks, Your Honor.
All right, and then, I mean, this is going to have to go through the process because your brief is going to look, I would imagine, different. And I don't mean the 20 pages different. I mean the focus is going to be different than it was previously. So, anyway, just work with the clerk you're going to have to file an opposition. And as to the issue of, because I want to understand this, the basis for the reply brief being, did the there are no cross claims. So you cross claimed the idea that he was seeking declaratory judgment, or he was seeking summary judgment on a cross claim, sort of went over my head because there are no cross claims.
He cross moved on our count one. He requested judgment.
Your Honor, essentially my opposition was coupled with a request that summary judgment enter in our favor. It didn't raise any additional issues. It just said that the...
Yeah, I'm not sure. I'm not going to get into this piece in the sense of there is no cross claim. I don't think you're entitled to the extra 10 pages either on the brief, but you're going to have to do some, if you think you are, you need to file a motion for leave. The reply brief should not be more than 10 pages based on what I understand the issues are here. You can convince me otherwise.
And I would think that the reply brief would most likely be unnecessary, whereas they already
Well-
know the terms of my opposition.
Well, and now
That's-
we've fully vetted, so under the
Right.
terms of what a traditional reply brief is, it's supposed to be issues you couldn't have anticipated.
That's what I mean,
And,
yeah.
and respect, just so I'm clarified, you are requesting summary judgment motion on the standing issue alone.
No, that's not what I said.
We can either,
Just,
we can either
that's it.
revise the summary judgment request. And the second thing is to address the separate.
And I want to be clear. I want you to be clear with me what you're, and this may, I'm not looking for an answer now. Really, what it is you need and what it is that you're asking for. And be focused on your prayers for relief and what you need to move forward. You may decide you're pursuing both of them. That's fine. I may segregate them and decide I'm going to give you a declaratory, I'm not deciding one way or the other on either of the issues, but I think that there are different issues swirling with those two, and I think we should address them separately. Right? And again, I encourage the parties to start talking again. There's a cloud that is presented by these issues, these legal issues that are not resolved in favor of either side, clearly on the law. And it seems to me that, again, 20,000 feet, there has been a change, a material change in the circumstances of the land, and there may be an opportunity to resolve the matter.
Thank you, Your Honor.
If I may, Your Honor, just so I understand initially, and I know I dropped it on the court today.
Oh.
So if it's not being handled as an emergency motion, they still,
So
they still have to comply with, there's no additional time. Is this being treated as a normal motion that was served today?
yes, and it's always dangerous when my clerk hands up something and,
No, I
and
do
you see
want-
if you saw the sea of paper on this side, I've already lost it, but I will find it again. You didn't take it back, did you?
I do not, Your Honor.
I didn't want to say you did, but I know you didn't. Hold on.
Number on it.
It's all right, I'll find it.
Is that it?
Yes, it is. All right. Yeah, I'm going to give, I'm just looking at it briefly. I'm going to give the defendant the standard time under 9A to respond to it.
May I be heard on that briefly, Your Honor? As I'm looking
What, you
at
don't
that-
want the time?
No, I appreciate that. But I guess I'm maybe going to overreach and ask for something additional. But it seems to me as I briefly flip through it, I'm seeing it for this first time, like, just as Your Honor is. The issues, the argument, the cases, everything seems to be basically a copy and paste in a different format than the motion for summary judgment. And it essentially says, since the Stigmatine Fathers have no chance of getting past summary judgment or prevailing in the end, that they want an attachment. Are we not putting the cart before the horse by hearing this before this Rule 56 hearing? I'm asking that we put it off in the
Well,
meantime.
It's all going to me anyway, so in order to get this, they are going to have to prove some likelihood of success on the merits under the attachment statute.
So this is
That's
considered.
not the same thing as is required for me to find summary, just a likelihood of success on the merits. It's a far lesser standard.
Fair enough. So this
Seems
is served
to me.
on me today. Under 9A, I have my
Yes.
normal. Thank you.
It won't be docketed until your opposition comes in.
Fair enough.
But we do have it, you don't need to file it. All right, anything else? And get with Madam Clerk when you have a date. I'm here, as I said, until the end of the year, but I'm only sitting civilly until the end of September, but I'll hear you afterwards. I'll be in the building.
Well, actually, could we set a date now? We're fine with September.
Sure, we can set a presumptive date and assume that the briefing's going to be done by that point.
Okay, thank you.
Madam Clerk, do you want to do it the first week of, the last week of September or the first week of October? You know what the rest of my schedule looks like, what looks humane.
17th too soon?
Yes.
Oh, this is the emergency motion.
No.
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 Well, the Rule 56 hearing couldn't happen they're going to reserve me in 2 weeks from now, and then I have 3 weeks from there.
Right.
So, and then a possible reply brief, so
Well, hopefully we're not going to have
Right.
the need for a reply brief.
but at the very least, we're talking 6 weeks out.
So we'll be across the hall, Madam Clerk, or I'll come over here.
Okay, I'll,
Again, given the exigencies, I don't understand this. Counsel had already admitted that there's not going to be much change from what he's submitted already to the summary
Oh,
judgment.
there better be change, because I'm asking you to brief an entirely
Well,
different
from our
issue.
point of view, I understand.
Well, and his opposition is going to have to, once you raise whatever comparable law there is out there that you believe gives me the authority to effectively shorten the statute of limitations, then I think he's going to have an opportunity to look at the law that says you can't. So,
10-2.
Well, I guess I'm not sure where.
That's
He's
10
coming 6 weeks out, and the way, even if we treat this as a brand-new summary judgment, there's only, I think, a 20-day response period. We're in August.
I guess it might be slightly less than 6 weeks out, just
we'll
approximately.
put it at 5 weeks. Thursday, October 3rd. Madam Clerk, how does that look on my schedule?
Actually, October 2nd is better for us.
All right, October 2nd it is.
It's fine, huh?
Thank you, Your Honor.
Matters continued. I will send notice.
Thank you.
Court's at recess, all right?
No, I'm good.